A man accused of killing a 22-year-old college student is officially indicted for murder, and now he's facing an additional accusation of being an alleged peeping Tom prior to the murder. Jose Antonio Ibarra was indicted on 10 charges, including murder, intent to rape, a peeping Tom charge, among others. In addition to the brutal slaying of 22-year-old college student Laken Riley, Ibarra is also accused of looking through a University of Georgia staffer's window on the same day of Laken's murder. Laken was a nursing student at the Augusta University College of Nursing's Athens campus. On February 22nd, Laken went out for a run, but tragically never returned. Her lifeless body was later discovered with visible injuries in the woods. According to court records, Laken died of blunt force trauma to her head. A Georgia grand jury handed down their indictment this week with more gruesome revelations. According to the indictment, Ibarra allegedly struck Laken in the head with a rock repeatedly, disfiguring her skull, asphyxiated her, and pulled her clothes with the intention of raping her. The documents say Ibarra hindered Laken's attempts to call 911, and he tampered with evidence by concealing a jacket and gloves. Investigators traced the brutal killings to Ibarra by pulling a photo from a surveillance camera, and the suspect was seen wearing a distinctive Adidas hat. It led them to an off-campus apartment complex where they conducted a search, piecing together clues which led back to Ibarra. Ibarra was booked for Laken's murder on February 23rd and has remained behind bars since. At the time, UGA Police Chief Jeff Clark said the murder was a crime of opportunity. Police said Ibarra didn't know Laken and took her life in a random attack.
Well, what it tells me is that Ibarra was hunting. I mean, he was literally hunting for a victim. And he peeped in this one potential victim's window. We'll probably never know why she was not victimized by him. But for whatever reason, he moved on and went out to the outdoor area where Laken Riley was running and spotted her alone and early in the morning, and obviously decided that she was going to be, or allegedly decided that she was going to be his victim. But I think the peeping Tom conduct suggests he was hunting, and that was the day he was going to find a victim. And tragically, that victim was Laken Riley.
Former prosecutor Francie Hakes explains young women face danger at a greater rate than young men.
Well, it's in my own backyard, and I'm an alumni of the University of Georgia. So I've been in Athens. I was there for years, and I've been to the location where Laken was murdered. Something I've discussed with male colleagues and agents and detectives many times. For example, how many men do you know who would go to a parking garage with their keys laced into their fingers, which is how we're taught, to have a potential self-defense weapon? Guys don't get taught that. They've never even thought about that because, of course, they just aren't the natural targets, unfortunately, that women tend to be. And so it saddens me, it disgusts me, and it enrages me that this alleged murderer seems to have targeted a beautiful young woman and taken her life for, horrible reasons. Well, sadly, women are raped and murdered all too often in every state, not just here in my home state of Georgia. I've prosecuted murder cases, I've prosecuted rape cases, of course, and in the offices I've worked, there were lots of those kinds of cases prosecuted. And it is sadly all too common. And I think, as women, it's very difficult for us to know what to do. And you get a mixed message if you're ever in a class that's trying to teach you self-defense, specifically about what to do if someone is making an attempt to sexually assault you. And you will get a different answer depending on who the instructor is. Some instructors will tell you, submit. And that's a horrible thing to hear as a woman. But the same instructor will say, it's not worth your life. Other instructors, of course, will tell you to fight as though your life depends on it, because, of course, your life might depend on it. And we can also tell, I think, from some of the facts in the indictment, including the charge about interfering with a 911 call, that Laken Riley was trying to save her own life. I don't know when she made that call. And our understanding from police is that that call didn't have any content. In other words, we don't hear her. So I'm not sure we're ever going to know exactly when in the sequence of events she made that call, whether she spotted him on the trail where she was running and called just for her own safety to have someone on the line, or whether she managed to make the call after he had already begun his assault on her. We may never know that. But it's clear that she tried to defend herself. And as women, I think it is very difficult to know what to do in that situation.
We need to take a really quick break from this really gruesome and heartbreaking story. If you know us at Law&Crime, you also know Morgan & Morgan is a proud sponsor of ours. And as viewers, sometimes our videos show the world isn't always safe. So if you're ever hurt, it can be confusing and scary, especially if you don't know where to turn. But we've got a little solution for you, because Morgan & Morgan, America's largest injury law firm, can help. Most of us, including myself, always have our phones on us. And with just one click, you can submit a claim and your injury could be worth millions. And the world is moving so fast. We can find ourselves oftentimes so busy, but it only takes a few minutes to see if you have a case. Plus, if you're injured, you never want to feel alone. Fighting big companies takes a big law firm. So with America's largest injury law firm, they'll be ready to take on insurance companies of every size. And Morgan & Morgan doesn't settle for lowball offers. So if you're ever injured, you can easily start by submitting a claim at www.forthepeople.com/LCnews or by dialing pound law, that's pound 529 on your phone. As authorities piece together several clues leading them to Ibarra being the alleged perpetrator of the crime, Hake says it's still possible to still put up an adequate defense for any potential trial.
It depends on what the evidence is. Someone was asking me today, oh, surely this is a slam dunk case. And I said, there almost really is no such thing as a slam dunk case, not to a prosecutor. To a prosecutor, you understand you can always lose, because the defense only has to get one person to hang the jury. And in this case, what I want to know is, do they have DNA? DNA evidence is obviously going to be very important in this case, because I'm not aware of any eyewitness to the actual assault itself. So the eyewitness in this case is Laken Riley herself, through her body, through her clothes, through her injuries, and possibly through her fingernails, if she was able to injure Jose Ibarra when she might have been fighting back against him. But if I'm the defense in this case, this may be, depending on the evidence, the kind of case to argue my guy is wrongfully accused. Like, literally, it's not even him. And I think there's his brother, who's present at the household, who may share some common characteristics with him, may be the same size. I know there's some gloves at issue and a jacket, and Ibarra may have been seen coming and going from that wooded area wearing that, but I think he was also wearing a hat. Those things are going to give the defense the ability, anyway, to make an argument that it's somebody else, that this is a case of mistaken identity. If there's DNA, it makes it much harder.
But for the prosecution's case, Hakes explains humanizing Laken Riley would be a great course of action.
In a prosecution's case, generally the way I always worked my cases when it came to trial was I worked in chronological order. Unless I had a really terrible witness, and then I stuck them right in the middle of the case and hoped the jury would forget about them if they had some sort of credibility problems. But I always went in chronological order, because ultimately you are telling the jury the story of the case, not a story in the sense of being anything that's not true, but the story of the case. What happened? Who was Laken Riley? What did she do that day? And I think the first witness for me would be her roommate. Actually called the police when she didn't come back on time, because that is maybe the most important witness in the case, because she is going to set not just the scene that put Laken Riley there in the path of allegedly Jose Ibarra, but she's also going to humanize Laken Riley. And that's something the defense has the ability to do with the defendant sitting in the courtroom, that the prosecution almost never has the ability to do, because the victim isn't sitting in the courtroom. So someone has to humanize that victim to the jury. She's not just a photograph. She's not just a snippet of videotape. She's a real living, breathing young woman who had hopes and dreams and who deserved to live. And so I start my case off with the roommate who can talk about Laken Riley, and she deserved to live.
But is it still possible prosecutors could strike a deal with Laken's alleged killer? With the death penalty still in effect in the state of Georgia, Hakes explains it could be an option.
Well, in this particular DA's office, I think it's possible, because my understanding is they may not be seeking the death penalty, because that DA in Athens has said she opposes the death penalty, although it is available in the state of Georgia. Now, there's a lot they have to go through in order to seek the death penalty. But if it is immediately off the table, if death penalty is off the table, then they may very well be pursuing a potential plea agreement, because there is some argument to be made that if you get a plea from the defendant, you can also extract from him an agreement not to seek an appeal or to appeal the sentence. And if that happens, the conviction is much more certain. It doesn't actually stop them from appealing. That's one of those secret facts people don't know about. They'll still appeal, but it may prevent any kind of substantive appeal later. And it would mean that all her family doesn't have to go through sitting through a trial like this every day. It's going to be a very difficult experience for them in the courtroom when there are things like autopsy photos being shown to the jury, what exactly happened to Laken Riley being testified about, probably through a detective or the officer who discovered her body, and of course the pathologist or medical examiner. And it may save them that experience as well. So it's possible that they are, even now, behind the scenes negotiating a possible plea.
But if the death penalty isn't an option, Ibarra is still facing the rest of his life in prison.
Well, for these charges, malice murder and felony murder, which most people think are sort of two different degrees of murder, like you have in other states, first-degree murder, second-degree murder, and that's not really the case here. Malice murder and felony murder carry the exact same penalty. Their elements are slightly different. Malice murder simply requires malice, but it doesn't mean you hate the person. It just means you formed the intent to kill in the instant before you killed. Whereas felony doesn't require an intent to kill. It merely requires that the death happened when you were committing another felony that you did intend, as in an attempted rape or an aggravated assault or some of these other, the aggravated battery. All these cases could be the precursor for the felony murder charges, which is why I think there are three of them. They've got alternative aggravated felonies as the basis for the felony murder. So he is looking at possible life or life without parole, depending on the elements of those particular offenses.
Jose Ibarra remains behind bars in the Clark County Jail. He will have to be arraigned on the charges, and depending on his plea, the case could go to trial. Reporting for Law and Crime, I'm Elizabeth Millner.